Judgment in the matter of an application by JR87 and another for judicial review.
Lord Stevens will hand down the judgment.
This appeal concerns proceedings challenging the legality of religious education and collective worship provided at a school in Northern Ireland to a pupil, a young girl then aged between 4 and 7. The proceedings have been brought by the pupil, whom we anonymise as JR87, and by her father, who we anonymise as G. The respondents to the proceedings are A, the Department of Education, and B, the Board of Governors of the school. The Transfer or Representatives Council, which represents the Church of Ireland, the Presbyterian Church in Ireland, and the Methodist Church in Ireland, is an intervener and has participated in the proceedings. In the proceedings, JR87 and G rely on Article 2 of Protocol 1 of the European Convention on Human Rights, read with Article 9 of the Convention as incorporated into domestic law by the Human Rights Act 1998. Article 9 guarantees everyone the right to freedom of thought, conscience, and religion. I will refer to Article 2 of Protocol 1 as Article 2. It provides, in part, that in the exercise of any functions which the state assumes in relation to education, it shall respect the right of parents to ensure such education is in conformity with their own religious and philosophical convictions. It is a legal requirement derived from Article 2 that religious education should be conveyed in an objective, critical, and pluralistic manner. JR87 and G contended that as religious education and collective worship in the school follows the core syllabus specified by the department, they were not conveyed in an objective, critical, and pluralistic manner. The department contended, A, that there was no breach of the requirement that religious education was conveyed in an objective, critical, and pluralistic manner at the school, and B, that the parents' statutory right to withdraw their daughter from religious education and from collective worship was sufficient to prevent a breach of Article 2. It is important in this short summary to emphasize several points. First, this case is not about secularism in the education system. As a matter of law, parents cannot object to the integration of teaching as to a directly or indirectly religious kind in the school curriculum. Secondly, this case is not about whether Christianity should be the main faith that pupils learn about in schools in Northern Ireland. It is within the department's power in planning and setting the curriculum for the greater part of religious education to focus on knowledge of Christianity. Thirdly, this case is solely concerned with the school environment. Parents retain in full their right to enlighten and advise their children and to guide them on a path in line with the parents' own religious convictions. Fourthly, there is no challenge in this case to collective worships in schools in Northern Ireland being focused on the Christian religion, or that in Catholic-maintained schools the focus of collective worship may be distinctive of the Catholic denomination. The sole challenge in this case concerns whether the religious education in the school was conveyed in an objective, critical, and pluralistic manner, and if it was not, whether the parent's statutory right to withdraw JR87 from religious education and collective worship was sufficient to prevent a breach of Article 2. In the High Court, Mr. Justice Colton held that as religious education and collective worship in the school followed the department's core syllabus, they were not conveyed in an objective, critical, and pluralistic manner. He also held that the parent's statutory right to withdraw their daughter from these activities was not sufficient to prevent a breach of Article 2 because exercising the right placed an undue burden on JR87's parents, a burden which deterred them from seeking withdrawal. Furthermore, withdrawal risked stigmatization of JR87. Mr. Justice Colton granted a declaration that the teaching of religious education and arrangements for collective worship breached both JR87's and G's rights under Article 2. The Court of Appeal, Keegan, Lady Chief Justice, Lord Justices Tracy and Horner, upheld the finding that religious education and collective worship in the school were not conveyed in an objective, critical, and pluralistic manner. However, the Court of Appeal held that the existence of the parent's unqualified statutory right to withdraw JR87 meant that the state was not pursuing the forbidden aim of indoctrination. Furthermore, the Court of Appeal very much doubted the fears of stigmatization or of an undue burden on JR87's parents would have been realized in practice. The appeal was allowed and the application for judicial review dismissed. JR87 and G now appealed to the Supreme Court. The finding that religious education and collective worship were not conveyed in the school in an objective, critical, and pluralistic manner was upheld in the Court of Appeal, and the Department did not obtain leave to appeal against that finding. No issue arises before this Court in relation to that finding. However, the Department did obtain leave and does cross-appeal on the issue of whether the judge erred in failing to separately analyse and determine the claims made by G and JR87. The Supreme Court unanimously allows JR87 and G's appeal and dismisses the cross-appeal for the reasons given in my judgment, with which the other justices agree, and I will now briefly summarise those reasons. In circumstances where religious education and collective worship is not conveyed in an objective, critical, and pluralistic manner, a factor to be taken into account in determining whether there is a breach of Article 2 is whether there is a right to withdraw JR87 without placing an undue burden on her parents. Mr. Justice Colton held as a fact that the statutory right of withdrawal was capable of placing an undue burden on her parents. There was ample evidence to support that factual finding. For instance, the parents' evidence as to potential stigmatization of JR87 was unchallenged, and that evidence was to be seen in the context that JR87 would have been the only child in the school who would have been withdrawn from religious education and collective worship. The Court of Appeal should not have departed from Mr. Justice Colton's finding that the parents had valid concerns in relation to withdrawing JR87 from religious education and collective worship. Also, the Court of Appeal fell into error in making a distinction between indoctrination and the state conveying information or knowledge in a manner which was not objective, critical, and pluralistic. The concepts are two sides of the same coin. Conveying knowledge in a manner that is not objective, critical, and pluralistic amounts to pursuing the aim of indoctrination. Furthermore, the Court of Appeal incorrectly imposed a requirement on the parents to establish that their apprehensions were objectively made out so that they would have been realized in practice. In considering whether there is capacity for an undue burden on the parents, reasonable apprehensions on their part are sufficient. As exercising the right to withdraw, JR87 was capable of placing an undue burden on her parents, there was a breach of Article 2, read with Article 9. G's appeal is allowed. The Department's cross-appeal raises the issue of whether the claims of JR87 and G should have been separately analysed and determined by Mr. Justice Colton. The Supreme Court agrees that the rights of parents and school children under Article 2 must be separately analysed. However, ordinarily, the outcome in respect of a complaint by a school child under the first sentence of Article 2 will be guided by the findings in respect of the parents' complaints under the second sentence of Article 2. In relation to JR87's rights, Mr. Justice Colton was therefore correct to be guided by the finding of a breach of G's rights under the second sentence of Article 2. Therefore, he was correct to find a breach of Article 2, read with Article 9 of the Convention, in relation to both JR87 and G. JR87's and G's appeal is allowed, and the Department's cross-appeal is dismissed. The declaration made by the judge is reinstated.
Thank you.